Welcome to Chapter 1 of my review of Guide to Computer Forensics and Investigation. We are using the 5th edition book, Chapter 1, Understanding the Digital Forensics Profession and Investigations. So the main objectives of this chapter is to describe the field of digital forensics. What does it mean by when you say digital forensics? Explain how to prepare a computer investigation and summarize the difference between a public sector and private sector investigations. Explain the importance of maintaining professional conduct. That's more like reputation. Describe how to prepare a digital forensics investigation by taking a systematic approach. Describe the procedures for a private sector and how they differ from public sector. Explain requirements for data recovery, that includes both workstation and software. And lastly, summarize how to conduct an investigation, including critiquing a case. So what is digital forensics? Digital forensics is the application of computer science and other investigative procedures for a legal purpose. Normally, this involves the analysis of digital evidence after proper search authorities, chain of custody, validation with mathematics, use of the validated tools. It is reputable reporting and possible expert presentation of the evidence and of the facts obtained from that evidence. In mid-2012, the International Standard Organization Standards for Digital Forensics was ratified. It is known as ISO 27037, Information Technology Security Techniques. So what does that mean? In a nutshell, digital forensics is any type of forensic recovery or forensic work encompassing the recovery and the investigation of materials typically found on a digital device. Often they're often related to computer crime. The term digital forensics was originally used as a synonym for computer forensics, but has expanded to cover investigation of all devices capable of storing digital data. So we have to be careful. When we start talking digital forensics, that's an umbrella term. If we're talking computer forensics, or if we're talking mobile forensics, if we're talking network forensics, those are more specific. So we kind of have to be careful. So the Federal Rules of Evidence was created to ensure consistency in federal proceedings. It was introduced early 70s. Many states' rules maps to the FRE. The FBI Computer Analysis and Response Team, or CART, was formed in mid-80s to handle cases involving digital evidence. So digital forensics has been around for quite a while. We're talking over 30 years. By late 90s, CART teamed up with the Department of Defense Computer Forensics Laboratory, and they became DCFL. So it's kind of interesting to see the different organizations and the growth of forensics from when they first occurred, when they first started happening, until what we see them now, because there's a huge difference. So the Fourth Amendment to the U.S. Constitution protects everyone's right to be secure from search and seizure. Separate search warrants may not be necessary for digital evidence. That's kind of important because as our technology has shifted, there have been reviews of, does a search warrant actually then allow for searching of electronic evidence, like Facebook, scanning of hard drives or flash drives or things of that nature. But they have found that search warrants do encompass certain digital evidence. Every U.S. jurisdiction has case laws related to the admissibility of evidence recovered from computers and other digital devices. You see that very heavily in the last year or years from the mass school shootings, where they've been able to find messages on cell phones to kind of help piece together, or even just recent terrorist attacks. Again, we're able to collect evidence from the devices that people use, and we're able to use that against them. Part of the other related disciplines could be investigation of digital devices. It's not always dealing with devices, but it's also dealing with the collecting of the data. That data has to be done securely, examining suspect data to determine the details, such as the origin and content. Did it really originate from that device type thing? Presenting the information to courts or to a hearing. Applying laws to digital devices and digital device practices. That way we can make sure that we're following all the appropriate compliances that we should be. Digital forensics is different from data recovery. Normally, data recovery involves retrieving of information that was deleted by mistake, not on purpose. So, forensics investigation often works as part of a team known as the investigation triad. The different areas are digital investigation, could be something like a network intrusion detection and incident response type team, vulnerability, threat assessment, and risk management teams. These three combined normally work well together. So what is vulnerability, threat assessment, and risk management? They test and verify the integrity of a standalone workstation and or network services or servers. Network intrusion detection and incident response detects intruders attacked by using automated tools and monitoring network logs. That includes things like a firewall log. Digital investigations manages the investigation and conducts forensics analysis of systems that are suspected of being compromised or that may contain evidence. Brief history of the digital forensics. Early 90s, the International Association of Computer Investigation Specialists, IACIS, introduced training on specific software used for digital forensics. The IRS created a search warrant program. The ASR data created expert witnesses for Macintosh. iLook is currently maintained by the IRS Criminal Investigation Division. My favorite, the Access Data Forensics Toolkit, or FTK, became a popular commercial product. So one of the next things we have to understand is some basic case law information. So you have to understand the existing laws can't keep up with the rate of technology changes, because again, laws take time to take effect. So when the statutes don't exist, case law is used. So case law basically allows for legal counsel to apply previous similar cases to current ones in an effort to address the ambiguity in the law. Examiners must be familiar with the recent court rulings on search and seizure in the form of electronic environments, the digital environment. So normally, investigators work hand in hand with court appointee, court officers, lawyers, things of that nature, because again, the lawyers, the court officers are going to be more familiar with the laws and the case laws than the examiners are. But again, they go hand in hand. It's not a single person that does this. Developing the digital forensics resources. Big part of this is we, the individuals, are part of a resource. And you have to continuously develop your skills, develop your resources. And that can be in part of teams or network of people. So we actually have an example of that type of group, which is the Computer Technology Investigators Network, CTIN, and they meet to discuss problems with digital forensics. And they also kind of talk about problems that they've encountered and they are faced with. That way, they can look at how do we solve some of this. You also develop and maintain contacts. Again, it's a professional network. So how do we prepare for digital investigation? Digital investigation falls into two major categories, public and private. Public could be things like government agencies. Private could be organizations or corporations. The public sector investigations normally involve government agencies responsible for criminal investigation and prosecution. Again, Fourth Amendment, U.S. Constitution, restricts government's search and seizure laws. So we have Department of Justice, or DOJ, updates information on computer search and seizures regularly based off of the current laws. Private sector, in contrast, investigations focus more heavily on policy violations, not search and seizure violations. So there are different things. Different agencies do different types of investigation. So when conducting a public sector investigation, you must understand the laws on computer-related crimes, including standard legal process, guidelines on search and seizure, and how to build a criminal case. Again, you're not only doing this by yourself, you're doing this with a team of people, so how to build a criminal case is probably not going to be you. Guidelines on search and seizure, you're probably going to have someone with a legal background that's helping with this. Standards for legal process, again, your normal role should be your role within that team of people, which would be the investigation. Interesting thing with dealing with public sector is the Computer Fraud and Abuse Act, which was passed in the mid-80s. Specific state laws were also then developed later, and they were generated off of the Computer Fraud and Abuse Act. Some were modified, but a lot of them were built generally off of the same guidelines. So again, we have to follow the legal process. A criminal investigation usually begins with someone finding evidence or a witness of a crime, an allegation to authorities. The authorities will interview and write a report. The report is processed and management decides to start an investigation or log the information for a police blotter. Blotter is a historical database of previous crimes, and nothing really comes of it. So again, the investigation has to happen first to see what are we going to do. Are we going to investigate this further, or is it just going to become historical? So there's a few things that are kind of important. Keep in mind that acronyms are going to be specific to the forensics area, like DES is not the same as encryption types. So I just wanted to point that out. So certain policies or processes that you should know about are the Digital Evidence First Responders, or DEFR, which basically arrives on the incident scene, assesses the situation, and takes the precaution to acquire and preserve evidence. Acquire and preserve evidence in accordance with their organization, accordance with local, state, and federal laws, assuming we're doing it within the United States. Digital evidence specialists has a skill to analyze the data and to determine when another specialist should be called in to assist. For example, my background is network security and computer forensics. I am not a mobile forensic specialist, so if I was examining a mobile device, I would know that this is outside of my scope. I need to contact a mobile specialist. Affidavit is a sworn statement of support of facts about or an evidence of a crime. Must include exhibits that support the allegation. Exhibits could be, again, items, could be reports. It's just material that will support the allegation. So within the private sector, investigation involve private companies and lawyers who address company policy violations, and normally they will litigate the disputes. Examples could be wrongful termination. Businesses strive to minimize litigation. They actually don't want to go to court. They don't want to have to pay fees. So being able to minimize the loss of funds because of law fees or lawyer fees is a huge plus. Private sector crimes could involve things like email harassment, falsification of data, gender and age discrimination. I'm sorry, discrimination, not just gender and age, but any type of discrimination. Any form of embezzlement, sabotage, or espionage. Those are all examples where private sectors could be involved. Termination, wrongful termination, harassment suits, things of that nature. Businesses have the ability to reduce the risk of litigation by publishing and maintaining policies. If you've ever taken a policy and procedural class, this is where this is going to come into play. You post the rules so everyone knows how to follow the rules. Most important policies define rules for using the company's technology-based assets, normally known as an acceptable use policy. If you don't have the appropriate policies that govern the use of your equipment, then that equipment can be used however people however they find it. But if you actually have a policy that states what you can and cannot do, then it's more limited. Line of authority states who has the legal right to initiate an investigation and who can take possession of evidence, as well as who can have access to the evidence. Businesses can avoid litigation by displaying warning banners. Again, it could be as simple as when you start your job, they give you the handbook. This is your handbook, sign this piece of paper showing that you understand your rights and responsibilities. And maybe every now and again, updated training on the new policies and procedures. Sample text that can be included in warning banners could be use of system and network is for official business only. One that would not be an appropriate one would be used for system access only, or a big pot leaf, or things like that. Normally you want to state what the resource is, and that it's for official or business use only. You don't want to use ambiguous terms. And you may have something like unauthorized or illegal use of this system or network will be subject to discipline or prosecution. Again, what can you do, and what are some consequences? Those are two really good examples. Businesses are advised to specify an authorized requester. They have the power to initiate the investigation. Example could be things like a corporate ethics officer or security investigator, or HR, equal employment opportunities officer, could be an auditor, or it could be as simple as the legal department. But again, you normally want to say who has the ability to authorize these types of investigations. During private investigations, you search for evidence to support the allegation of violations of the company's policies and procedures. Typically, there's three common situations: abuse or misuse of technology assets, electronic abuse, whether it be communication, email, or internet-based. I know we'll classify both of them as communication-based, but depending on your organization. A private sector investigator's job is to minimize the overall risk to the organization. How do we do with that? What's really funny is we have this whole bring your own device environment. So some companies have not developed their BYOD policies. So if you're watching porn on your own device, on your break, is that acceptable? Is it not acceptable? So it just kind of depends. So you have to have an understanding of the distinction between personal and company property. And that's kind of difficult, especially with the merging of our personal and professional worlds. So BYOD just adds a whole nother layer of complexity to this. That's where you have the professional conducts, things like a person's morals and ethics, as well as their standards of behavior. That's where this comes in. Investigators typically have a very high moral standing. Normally they have ethics that they do follow, because again, it's reputation. They also have the ability to keep their objectivity, meaning they're not easily manipulated. They're not easy to change facts or interpret facts incorrectly. They stay objective. The big thing here is the credibility, because if the professional is not credible, everything that they touch could be tainted. And normally, credibility is maintained through confidentiality. So the investigators should also be trained to stay current with the latest technology changes in forensics and hardware, software, networking, in those key areas. Because again, those are areas that they're going to be working in. So let's talk about how to prepare digital forensics investigation. So again, the role here is to gather the evidence and to prove or disprove the suspect has committed the violation or crime. So the collecting of evidence that could be offered in a court or a corporate inquiry. So they investigate the suspect's technology assets, could be a computer or more, but we also have to preserve the evidence on a different computer. So maybe we're not really doing the work off of the suspect's computer. We maybe copy the suspect's computer and we do all of the example or the examining on that copy of it. Another big thing when we talk about investigation is the chain of custody. What route does the evidence take from collection to court? And is there the appropriate paper trail that goes along with it? So a general overview could be of computer crime, because computers can contain information that help law enforcement determine chain of events or evidence that could lead to a conviction. Enforcement officers, again, if they're following the appropriate procedures when they're acquiring the evidence, because digital evidence can be easily altered by an overeager investigator. And once it's altered, it's no longer admissible. So a potential challenge could be information on a hard disk that might be password protected, so a forensics tool may be needed to be used. But then what are some consequences to that? What has to change in order for that tool to be successful? An overview of the organization's policy and violations. Again, the misuse of resources could cost organizations a lot of money. That misuse could be as simple as surfing the internet, sending personal email, or making copies from a library, depending on the organization. So using the company's computer for personal tasks could cost that organization a lot of money. So let's talk about a systematic approach to solving problems. So steps for solving a problem is, let's make an initial assessment about the type of case we're investigating. Let's determine a preliminary design or approach to the case itself. Let's create a detailed checklist, determine the resources, and obtain and copy an evidence drive. If we're collecting data on someone's hard drive, we want to make a copy of it so we're not working off of the original. Also, we could identify risks, mitigate the risks, test our design, analyze and recover the digital evidence, if allowed to, investigate, complete, document, critique, present. Those are general guidelines for systematically reviewing everything. So how would we assess the case? Again, systematically create an outline, so the situation, the nature, the specifics, the types of evidence, the known disk formats, and location. We're going to base all of our information off of these details, and you can determine the case requirements. So part of this is also planning your investigation. So basic investigation plan should include things like, how are we acquiring the evidence? How are we completing an evidence form so that we can document the established chain of custody? What about transporting of evidence? What about securing the evidence in the appropriate type of office environment, as well as in the appropriate type of secured container? Also, about prepping our workstation for our forensics investigation, retrieving evidence from the secured container, again, properly, so we're keeping everything documented, making a forensic copy of the evidence, returning the evidence to the secure container, working off of the forensic copy, and we're going to process the copy with our forensics tools, again, leaving the original alone. That way, if something happens, we can always fall back to it. That evidence custody form helps you document everything. There are generally two types, single evidence or multi-evidence. And here's a simple form for planning your investigation. The appropriate forms and everything. So this is an example of a multi-evidence form. This is an example of a single evidence form. Part of the collecting of evidence could also be how we collect it, how we organize it, how we bag it. Do we have evidence bags? Are we documenting it? Are the evidence bags clean? Are they protected? Are they anti-static? Are they well padded depending on how fragile what we are collecting? Do they seal? Do they provide discharge? Are they resistant to discharge? So there's a lot of things that goes into what do we do when we're collecting evidence? Like, how do we actually store it before we actually transport it? So after we secure our evidence, you write your initial on tape to prove the evidence has not been tampered with, and you tape over the opening. That way, the only way to open it is to cut through the tape that you'd laid and signed. So consider computer specific temperatures and humidity ranges. You have to understand the environment that your technology is going to be working in. That way, if you know you're collecting a piece of evidence that's going to be frozen, you're not putting it in a 100-degree temperature room. You're putting it in probably a frozen room or a 32-degree Fahrenheit type room. Because again, you want to make sure things like temperature and humidity are appropriate for the evidence that you're collecting. So procedures. As an investigator, you need to develop formal procedures as well as an informal checklist. You want to make sure to cover all issues that are important to a technology-based investigation and ensure the correct techniques are used always within the investigation. Again, it goes back to the documentation process. That way you can show the steps that you take. If we're looking at some type of an employee termination case, because the majority of investigation work for termination cases normally involves employee abuse of corporate assets, we're going to be able to document incidences that create a hostile work environment. Typically, they are the ones that are predominant types of cases to investigate. They're not the only, but they're one of the biggest ones. Sadly, the big two ones here, porn and inappropriate emails, work. So that's why organizations have to have an appropriate policy in place that is clearly defined, not using ambiguous terms, and you outline consequences. So things like internet abuse investigations, you could organize records, you could organize logs. Your organization could also then have a proxy that then logs everything. Maybe you're looking at this suspect's computer or the IP address of that computer, the disk drives, and again, once you have that information, you can have forensics analysis tools verify it. Internet abuse, again, you're going to be using standard analysis techniques. You're going to use the appropriate tools to extract web pages or web URLs. You can look at the network traffic logs. You could talk to the network administrator to see if there's firewall logs or IDS/IPS logs, or what logs are there that actually are monitoring the traffic. You can look at the data recovery, and then again, you continue to analyze the computer disk drives data as well. Email abuse, again, it's going to be very similar. An electronic copy of the offending email that contains the message header data, that's going to be huge. That gives you the details that you're going to need. If available, an email server log. If available for email systems, store user messages on a centralized server. Normally in a business environment, if you're using Microsoft Exchange, there you go. Access to the computer so that you can perform a forensics analysis on it, or at least a copy of the data on the computer. And again, your preferred forensics analysis tools. To conduct an investigation, when it deals with email, you're going to be looking at things like, again, your typical tools. You're going to have an electronic copy of the suspects, as well as the victim's email folder and their data, preferably. For web-based access email investigations, you're going to be using tools such as the FTK's Internet Keyword Search option to extract all related email address information. We're going to be looking at the header data of all the messages of interest to the investigation. So what does that really mean? Basically, you're going to be looking at the source and destination machines. You're going to be looking at the header information within the email to verify that the sender really sent it, and that the receiver truly got it from the sender, and that they did not manipulate it in any way. Let's talk about attorney-client privilege investigations. Normally, when there is an attorney and there is a case or an investigation happening, the attorney does have what's known attorney-client privilege. And basically, you must keep all findings confidential if you work within the attorney side, or if your investigative team has that attorney-client privilege. Many attorneys like to have printouts of the data you've recovered. You need to persuade and educate many attorneys on how the digital evidence can be viewed electronically, and how insecure the printed copies may be. Because again, data theft is a huge issue. You can also encounter problems if you find data in the forms of binary files. It's really hard to export a binary file into a physical file, such as a Word document. So steps for conducting a client-attorney privilege case. Normally, we're requesting a memorandum from the attorney directing you to start the investigation. Again, you're working as a team member. You're requesting a list of keywords of interest to the investigation. This can be done through like regular expression and things of that nature, but we're going to talk about that a little bit later in our lab. They initiate the investigation, the analysis. If we're having to do any type of disk drive examination, again, make 2 bitstream images. So what's bitstream? Bitstream is a bit-by-bit copy. It's a 100% duplicate copy of the disk or the medium that the suspect is going to be had. Again, we do not work off the original data. We work off a copy of it. And how do we verify that the copy is as close to the original as possible? we do that with a bit stream copy. Normally, bit stream is also referred to as a forensics copy. And what we can do is we can compare the hash signatures on all files on the original and on the recreated disks, thus verifying that they truly are a bit-by-bit copy. So when you're doing the drive analysis, you have to methodically examine every portion of the disk drive, extract all the data, because again, you don't know what data is going to turn into meaningful information. I want to talk a little bit more about that when we talk about this in form of whether Windows, Mac, or Linux in later chapters, but I just wanted to point that out now. You're going to be running keyword searches, both on allocated and unallocated disk spaces. You're going to have to understand the differences between major operating systems like Windows OS and the specialty tools to analyze and extract data from key components within that operating system, such as the registry. Binary files could be like CAD drawings. So I mean, there's lots of small things that you have to be aware of. Consolidate all of the recoverable data from the evidence bitstream image into folders and subfolders, again, so it's easily analyzed and easily able to be sorted and organized and gone through. Minimize written communication with the attorney. I don't know why they have that, but I disagree with that. You want to document as much as possible, but again, making sure all of the documentation is secure. Any documentation written to the attorney must contain a header stating that privileged legal communication or confidential information or anything like that. Again, you want to be able to communicate, document, but keep the communication secure. So let's go ahead and move on to espionage. Espionage is kind of interesting because all suspected industrial espionage cases normally are treated as a criminal investigation. Staff that's needed, again, it's not a single person. Normally a threat assessment specialist, normally an attorney, networking specialists, some type of technology specialists, and normally a computer investigator. Each of the different specialists are going to have their own unique specialties. For example, the computer and network specialists are going to specialize maybe both in digital forensics, but in different aspects of digital forensics. One may focus on the network side, or one may focus on the computer side. Again, these are specialists. So, guidelines when the initial investigation does occur, determine whether this investigation involves, if it is really corporate espionage or espionage. If it is, then we need to consult with the corporate attorneys as well as the upper level management. We need to determine what information has been breached, and we also have to understand how substantial these allegations are. Like, this is not something that's light. Like, this is a huge allegation. So we want to make sure that we have the appropriate information backing this allegation. We need to generate a word list for our disk forensics, as well as our sniffer monitors. And we need to start collecting and listing all of the appropriate resources for the investigation. What's a word list? A word list could be as simple as, these are the items that we think had a breach, and they contain the following words. And you want to be specific. You can use third-party programs or like regular expression to scan internal documents. That way, you're not just searching for the title of the document. You're actually searching for the content within the document. Other guidelines are to determine the goals and scope. How far are we going with the investigation? To what point? To what end? Initiate the investigation only after the appropriate powers have given permission. And then you're going to plan accordingly. So part of that planning and planning considerations could be maybe starting off looking at all the emails, looking at all the communication between the employees. search internet news groups or message boards. I don't know why that's there, but that's always a good idea. If you think certain information was posted online, you may want to initiate physical surveillance. Again, this is getting way outside the realm of digital forensics, but I mean, physical surveillance could be an option for certain levels of investigation for the appropriate team member. Examine the facility's physical access logs for sensitive area breaches and for the assailant who you believe may have caused those breaches. Again, that's getting way outside the scope of our digital investigation, but again, it could be appropriate for the right person on our team. Okay, so one of the other things for that planning should be to determine suspect's location in relationship to the vulnerable asset. Study the suspect's work habit, collect all incoming and outgoing communications, whether it be phone, whether it be email, analyze them. Again, some of this is getting to the point where we're more like a private investigator, not so much a digital investigator, so do keep this in mind. So steps to conducting an industrial espionage case. Gather all the appropriate personnel assigned to the investigation. Brief them. Because again, this is not normally done as an individual. You guys are a team. So we're supposed to be doing our collective parts. Again, this course is mainly designed for you to understand your role within that team, as well as how to function in your role. So some of this seems kind of like very broad, like surveillance and tracking of people. That's not really our area, but again, that's something that does happen within this type of investigation, even though it's not part of our role. So additional steps is surveillance key locations, discreetly gather, again, information and other additional evidence. Logs, collect as much documentation as possible. Report regularly to the appropriate authorities, whether that be management, corporate ethics officer, the corporate general counsel, or the attorneys. Again, regular communication. Make sure to stay within the scope that was outlined for you. Remember that scope is outlined by management as well as the general counsel or corporate attorneys, because they know the scope that they want you to be working within for the potential or case that they are building. Because again, you're collecting evidence. You are providing the factual components of the case, but they are still putting together the case. Interviewing and interrogation in high-tech investigations. Again, I'm not saying we're doing interrogation. This is just one area or one aspect of this as it relates to the whole process. So sometimes we have to interview and interrogate the appropriate people, but this is normally something that takes years of experience and is not typically done for forensics investigators. Interviewing, maybe. Interrogation, probably not. So it's usually conducted to collect information from a witness or a suspect, and normally about the investigation or about the subject of the investigation. Interrogation is the process of trying to get a suspect to confess. I guess that's one definition of interrogation. But again, not normally what we're going to be doing within the scope of our digital forensics. So the role as the computer investigator is to instruct the investigators conducting the interview on what to ask. Because again, this is our area. Our area is the computer forensics portion. Not surveillance, not interrogation, not breaching, but more the investigator specializing on the computer component. Because again, the investigators are going to rely on our expertise in that area. So the ingredients for a successful interview or interrogation, I'm sorry, the interrogation is still going to make me continuously laugh, is being patient, repeating or recreating questions to zero in on the specific facts, and being tenacious, not giving up, staying with it. So let's go on to understanding data recovery, both on the workstation and the appropriate software. So investigations can and are conducted on computer forensics lab equipment or some type of data recovery equipment. Normally, you're going to have a workstation that will have the appropriate software. It could be a specialized PC. So we need to make sure that we have the appropriate software and hardware to access it. Since we are not going to be altering evidence, we need some type of write blocker device. A write blocker device enables you to boot to Windows without writing data to the evidence drive. Because again, the goal here is not to alter. Just like when you're working on a cell phone, you're not going to want to alter the information on the cell phone. So how do we set up a workstation for our digital forensics? Normally we want a newer workstation. We want a write blocker device. We want the appropriate acquisition and analysis tools, maybe target drives, spare drives, and USB ports. Some additional items that may be useful, obviously a NIC, because again you want to be able to communicate. The appropriate ports that you're going to need could be USB ports, could be FireWire, could be SCSI, could be eSATA, but the appropriate ones that you need. Normally, you're also looking for the appropriate software, whether that's going to be a disk editor or text editor, or viewing programs for specific types of files. Those are all very common types of software and additional hardware components that you may need for your workstation. So how do we conduct an investigation? We gather resources to identify in the investigation plan. So we're going to need certain items. We're probably going to need the original electronic items that we're going to be making copies of. We're going to need the appropriate evidence custom forms and the appropriate evidence containers. We're going to need some type of bit streaming tool. We're going to need some type of forensics workstation so we can do our work. And lastly, we're going to need some type of secured area to work in. The goal here is to avoid damaging the evidence. So in order to do this, we may need to meet with a few people, like meeting the IT manager, filling out the evidence form, placing the evidence in a secured container, carrying the evidence to the forensics lab, completing the evidence custody forms, and then re-securing the evidence by locking the container. So now let's go ahead and let's bring up two main things, bitstream copies and bitstream image. Since I kept talking about bitstreams before, we need to go a little bit more in depth. So a bitstream copy is a bit-by-bit copy of the original storage medium, also known as a forensics copy. It is 100% identical copy. It's different from a simple backup copy because the backup software only copies known files. The backup software normally does not copy deleted files or email messages or even recover file fragments, where a bitstream copy can. Next is a bitstream image. This is a file containing bitstream copy of all data on a disk or partition, known as an image or image file. So let's look at a graphic to get that a little bit more in depth. So again, the original disk, and we have two image disks. They're going to be copies. They are going to be 100% identical to the original disk, and we can verify that through hashing. That way, every single bit is copied over. So acquiring the images of evidence media, we have to preserve the original evidence, always. We want to conduct our analysis only on copies. we want to include a write blocker. That way, we do not alter any systems. Or other write blockers for the appropriate type of hardware that you're using. For example, a cell phone or a tablet, they're going to have specific write blockers for those types of devices. You want to create the appropriate work folder for your files. You want to be organized about this. So how are we going to perform acquisition on the USB drive? On the USB drive, we're going to, again, locate the write protective switch, assuming there is one. We're going to be using ProDiscover Basic, and we're going to go through the appropriate options. Again, this is going to be one of our labs in our lab book, so don't stress too much out about this. Here is the appropriate ProDiscover Basic tool. And again, we're going to follow the steps until it is complete. Destination, we're going to fill in. We may even label it. We're going to organize it. So our job, after we've imaged it or copied it, is to recover data and analyze. So for the data recovery, we're looking for things like deleted files or file fragments, or even recovery of a completed file. Because sometimes that happens. Deleted files linger on the disk until new data is saved on the same physical location. We're going to get into this pretty in depth when we get to our hard drive chapter, because there's a lot going on with our hard drives that many people aren't aware. So I wanted to put that out there. Tools that can be used to retrieve deleted files could be as simple as ProDiscover Basic. This is a basic tool we're going to use for our labs. This is not the only tool. This is just one of the few. So again, steps to analyze is start the discovery. We want to create a new case, maybe fill in the appropriate project number. That's going to be tied to our documentation. We're going to add the image file that we created of the original file. And we're going to start looking at the content view. We're going to be looking at all of the files underneath the image, because again, we're not working with the original data. We're working with a copy of it. So we can look at all files that are on it. Partial, complete, everything. So again, steps to display the acquired data is click on the letter 1 to view its content, or click on the appropriate drive to view its content. Now we're going to start being able to analyze the data. We can start searching for information. We can start a basic data analysis, but keep in mind, this is actually also one of the most time-consuming devices. Most of my background is actually done in EnCase, so we're going to have to get familiar with different software tools and what we call our different window panes. For example, here we have a work area and a data area, and probably a navigation area on the left. This is mainly about how to use ProDiscover Basic, which we're going to be using that in conjunction with our lab book, just so that you're aware. With ProDiscover Basic, we can search for keywords, we can actually export and import and keep organized, as well as generate reports. We can analyze, we can search, we should be able to load specific patterns and names, dates. Again, there's a lot that you can do with an analytics tool. We can get down into the machine language or the hexadecimal or the bits of it. We can analyze the appropriate items, and we can also look at basic reports that are generated within ProDiscover Basic. And one of the last things we're going to have to start doing is we have to make sure that our findings are repeatable. We document it, we follow the same governed patterns that are outlined in best practices, and we make sure that someone else, with our findings, with our documentation, with everything that we started with, is able to come up with the same conclusions that you were. Once we've done that, we produce a final report. We state what you did and what we found, and again, we make sure that it was repeatable. We document everything. Normally for this, we're getting a report template. We're not just kind of creating it on the fly. Report should show conclusive evidence the suspect did or did not commit the appropriate violation. Like everything else you do, you keep a written journal of everything you do, your notes, just in case. You want to answer the typical 6 W's: who, what, when, where, why, and how. And you must sometimes have to explain what computer and network processes are and the forensics process working within them. The last step is critiquing the case. You ask yourself the following questions. How can you improve? How can you improve your performance? Did you expect the appropriate results? Or did you expect the results that you got? Did the case develop the way that you expected? Did it develop in a way that you did not expect? Was the documentation as thorough as it could have been? Could you have been more thorough? What feedback did you receive? And could you incorporate that feedback later? Did you discover any new issues? Did you document the issues? Did you look at any new technologies or techniques that could have been improved or been done in your investigation? That's actually it for this chapter. Again, keep in mind, be systematical. Make sure that we are doing it with the appropriate tools and software and hardware, because again, this is going to be a specialized workstation, specialized tools. Understand the difference between public and private sectors. Again, keep in mind that systematic approach always. Understand what criminal cases are, understand what corporate policy violations are, understand things like chain of custody, bit streaming, the importance of documentation on journaling, things of that nature. That's actually for this chapter. I want to thank you.